Hi, this is Kent Jones with Jones & Associates in Cleveland, Tennessee. We cover Chattanooga and Cleveland and areas outside there on occasion. I'm going through a book I wrote in 2015 on personal injury in Tennessee, and we're now on Chapter 8, which regards products liability cases. Generally speaking, products liability cases are more difficult to maintain than your traditional negligence case. Even if you bring one in state court and have complete diversity of citizenship, and there is over $75,000 in controversy, then there is a 99% chance that the defendants will remove you to federal court. Unless you have a non-diverse defendant, and they technically have a right to do this. And even if you have a non-diverse defendant, the case could be severed to federal court. Federal court cases are a bit easier to handle from a paper perspective because most of the filings are done through the system online. But by the same token, the standards in federal court are considerably higher than the standards in the state of Tennessee. In federal court, and I think we discussed this in an earlier segment, we've got the Supreme Court cases of Iqbal and Twombly, which raised or heightened the pleading standards to one that requires a lot more particularity than what was more or less taken for granted for years as form pleading. So the first thing you're going to have to do in federal court is show, according to the last case I tried at the Supreme Court, the Sixth Circuit Court of Appeals, that whatever happened to this person due to the defective or dangerous product is out there and has happened before. Sometimes it's fairly easy to find. You can go to the consumer internet sites and look up the product and see if anything has been reported on it, and that's probably the first course of action I would take. And if you find that, yes, that product has done the same thing, caused the same problems before, then it's more probable that you can survive the stringent pleading standards in federal court. The next thing that you'll probably run into if you overcome the hurdles of those Supreme Court cases and all the district court cases that have interpreted them is a motion for summary judgment from the defense. And in a motion for summary judgment, they don't just look at the complaint on its face and determine whether or not it's plausible or not. In that particular situation, by then you should have depositions and affidavits and a lot more material that will be considered by the court. In 2015, it became much easier for defendants to succeed at motions for summary judgment. And I'm not going to go into detail in this CliffsNote version about the particular standards set forth in Rye and the legislature, but the fact remains that if you want to survive summary judgment, you still have to show that there is a genuine issue of material fact. And what is a genuine material issue of material fact? Well, first of all, the fact's got to be material, and usually you'll confront several different facts that are considered material to the case. And if you have a genuine issue of material fact, and that's something that a jury is supposed to consider. So it should not be dismissed on summary judgment. If you don't have a genuine issue of material fact, then the mover of the summary judgment can be entitled to a judgment as a matter of law. Products liability cases can be very expensive. You're going to run into a number of expert reports from the defendants, and likewise on your side as a plaintiff, if you're going to have expert reports that support your position. Products liability cases are certainly not the type of case that you want to bring yourself. You need a lawyer who's done them before and been through the case law and the hearings and understands all of the obstacles that can come into play in that particular type of case. What is an example of a products liability case? Well, consider a drug that recently hit the market, maybe a couple of years before, started causing problems, let's say a disease, maybe it's pancreatitis, and you have all those statistics out there on that particular drug, then you've got a drug that may be causing a condition that's subject to products liability and statutory case law. What's applied there in those particular types of cases. That's going to be all I'm going to say about products liability for right now. Those cases don't come as frequently as many of the other cases that we've spoken about in this series. I appreciate listening to us. Again, we're at 1441 Guthrie Drive, Northwest, Suite 101, Cleveland, Tennessee, 37311. We're the landmark best is if you get off I-75 and head down 25th Street towards Key Street. We're a couple blocks down in the big, recently renewed Heritage office building behind the Burger King. Thanks a lot. Hope everyone has a great day.